From supplementary cost list, item number 1 for pronouncement of judgment.
So there are 3 appeals, all related to the same accident. So this court has passed a common order. I'll read out only the operative portion. In the final analysis, this court has come to the conclusion that the impugned judgment and order does not suffer from any infirmity and is therefore not liable to be set aside and quashed. The same is hereby upheld. The appellant insurance company is directed to comply with the direction of the learned tribunal and to make payment of the compensation awarded to those entitled to herein within a period of 2 months from the date of receipt of certified copy of this judgment. Thank you.
Thank you very much.
Yes.
At least, the item 5 to 9, these are analogous matters, that Assam Rifles matter. Now, item 9, this Makanmi Kengo, I require a week's time more. I could not complete the written argument. That is WPC 217 of 2017.
And I think you're required to answer only in item 9, isn't it?
Yes, yes. But since these are analogous matters, so I'm praying for a week's time. I could not complete, though I had started one.
Anyway, the saving grace is that there's an interim order in your favor.
Right.
So the longer it goes, the better for you. Perchance it might go against you.
Protection.
Leonard G, appearing for the state respondent, has sought for some more time to file the written argument, particularly in
WPC 217 of 2017.
WPC 217. WPC 217 of
2017.
2017. On the same not being objected to by petitioner. Prayers allowed. 1 week?
1 week.
Let's just matter up to 1 week.
About item 10 of the hearing this one. But Mr. Sen Gupta, he's not well mannered, so he left today. But he has requested for this adjournment. But item 10 and item 17.
It's 2015 matter.
My lord, but he's not feeling well.
That has been heard.
My lord, this is the jail.
Oh, that jail.
17.
Again, here is also your advantage. You're staying where you're not supposed to stay. You could have gracefully left the quarter, but of course the
benefits are still
the question of the dues and entitlement on prey made by the respondent. This is matter after 1 week.
My lord.
Please. Also, I would like to mention one writ petition to be listed tomorrow, my lord, being an urgency of the subject matter.
What's the urgency?
It's my lord. On day after tomorrow, my lord, one interview is being will be conducted, my lord, for the post where already post has been approved by the cabinet of the petitioner, my lord. So now against this process, my lord. Highly blessed.
May I please, Your Lordship, I beg to mention item number 19. I'll give 2 weeks time, Your Lordship. The senior conducting counsel is out of station.
But I think we have agreed that this matter would be heard today. On whose behalf?
Respondent number 1, Your Lordship.
Who is the petitioner? On pre-made by the respondent, not objected to by petitioner. This is matter after 2 weeks.
Me, please, Your Lordship. Lordship, I beg to mention item number 16, Your Lordship. Lordship, I pray for 1 more week time, Your Lordship. Mr.
This is Lordship. Lordship, so far this case adjournment after adjournment for how many months, how many weeks they will take, Your Lordship. In fact, Your Lordship, this is a covered case, Your Lordship.
Matter has been heard.
Lordship,
Was the matter heard?
Lordship.
No, the matter was heard, or what are we here?
Lordship, they sought for adjournment, Your Lordship. In fact, there is in my humble and respectful submission, Lordship, there is nothing to be decided, Your Lordship, because Lordship will kindly recall that Bhomik case, Your Lordship. In that case, they went to some court. That some court had dismissed the special petition, so it will cover, Your Lordship.
Lordship, let Mr. Thapa come, Your Lordship, after 1 week, Lordship, let it be the last chance, Lordship.
Go through the brief and see. If you have no case, means no case. Why would you hang on?
The only solution for them is to withdraw the writ petition, Your Lordship, not to seek adjournment.
Limited instruction, Your Lordship.
What you can do, you can step in the shoes and make the solution.
No, Lordship, because Lordship, there is no unnecessarily the writ petition has been detained, Your Lordship, unnecessary.
1 week then.
Habla, Your Lordship.
On pre-made by the petitioner, this is matter after 1 week.
I will please, Your Lordship. I'm praying for 2 weeks time, item number 14 and 15, Your Lordship.
(14, 15).
Your Lordship.
On whose behalf?
For the respondents.
Respondent. Who is the respondent here?
Shillong Cantonment Board.
What is your ground?
Your Lordship, because my senior is still under medical treatment, Your Lordship.
Who is your senior?
Steamer Hunter.
And for the item number 15.
Your Lordship, we have the petitioners. For the petitioners. 14.
14.
Prayer has been made for seeking adjournment on behalf of the respondent, Shillong Cantonment Board, on the ground that the Red Senior Counsel is indisposed on account of ill health. On pre-made, the same is allowed. This is matter after
2 weeks.
2 weeks. 14, 15.
On supplementary cost list, item number 4.
My Lord, this matter has a long history. Why we filed this writ petition, my Lord? Here, I'll take a Lordship attention to the annexures. My Lord. Shortly. Lordship, may kindly turn to page number 22. Page 22. It's the first title suit, 1990, instituted by the CM of Langrim.
Yes.
Against the 2 defendants are there. And this area comprises a huge area in the Langrim CMship. Defendant claimed for the ownership, so the CMship instituted the suit, and suit was pending. During the pendency of the suit, my Lord, the son of the defendant number 1, now who is the chief now, he became the chief, elected as a chief. Now, without consulting the residents there, he reached a compromise with his own mother and obtained the compromise degree. And compromise degree is, my Lord, available in page number 38. I'll not go through the content, but I'm briefly, my lord, narrating the background.
Yes.
My lord, 2012. Thereafter, my lord, the many residents agree with this, agree about the situation. Therefore, they file a separate suit, that is page number 48. Around more than 600 plaintiffs are there from the CM ship. This was the suit, 2012. And this was continued. And page number, Lordship, kindly say page number 80.
80.
80, man. 80. The collector was informed by the petitioners in that plain also, as well as the present petition, one of the petitioner, that during the pendency of the suit, my lord, the land acquisition took place. And huge area of the land of the same ship was taken over for public purpose. So petitioner here, as well as other, they have no grievance. Only the grievance is that compensation should be paid in accordance with law. Now, since the suit is pending between the two parties, same ship and the individual citizen there, therefore inform the collector that don't release the compensation until the title is settled by the trial court. 2019. And thereafter, my lord, page number 82. 2019, my lord, collector requested the residents, including some of petitioners here, to hand over the area for construction of the public road. So they handed over. But page number 81 is the handed over. 81, 82, 83 are the handing over. And, my lord, thereafter, my lord, some of the residents, they filed an application, page number 84, my lord, seeking for recalling, my lord, recalling of the order passed, recalling of the compromise decree, page 84 onwards. 84 onwards.
Yes.
My lord. And the case was pending. Thereafter, my lord, page number 85. Page 85.
85.
85, my lord. Now, what happened is the defendant in the title suit filed dismiss case number 3 of 2021, seeking for dismissal of that 2007 suit, saying that since compromise decree is there, you cannot maintain a separate suit. If you agree, you have to file an application for recalling whatsoever. It's a public property. So, on the basis of this application, trial court has dismissed the 2017 the 17 title suit. And, my lord, thereafter, what happened? Page number 124. 124. This, one of the recent petitioner, and with others, my lord, they filed dismiss case number 38 of 2021, seeking for recalling as well as seeking for condonation of delay. They spent almost 10 years pursuing the second title suit.
Condonation of delay for what?
Condonation of delay for filing this application for recalling.
Okay.
Recalling. And recalling. My lord, page number 130, during that pendency of that application for recalling. Now, what happened 2020, the chief respondent number 2 has given 160 acres of land to the government, free of cost, for construction of the civil division, subdivision, and 40 acres for construction of the school, without the, my lord, consent of the public. And this area, my lord,
Who is or who are the owners of the land?
this is the, my lord, the same ship land. Same ship land.
So if land is given away by the chief,
My lord.
should have been, on the strength of a resolution.
Yeah, the strength resolution and Darbar,
Darbar,
consent of the villagers are there. He did not obtain all this.
On his own. Yes.
On his own. Therefore, these people, my lord, in page number 130, they filed a separate suit, title suit number 1 of 2021, against the collector who received the land on behalf of the government, and the chief also there as a defendant number 3. Now, the situation is that the second suit land also located in the previous suit land, which is pending. Now, collector has filed the WS page number 144. and contesting the suit. 2021, he filed the WS also. And the chief also, page number 149, chief also filed a WS. WS.
Yes.
WS. Now, later on, my lord, page number 160, my lord, the present petition number 1, who also filed the application for recalling, page number 160.
Yes.
Well, seeking for recalling of that earlier compromise decree, he filed this application along with my lord, page number 170.
What is this application?
Application for recalling, my lord. Early recalling was filed by another people from the residents.
It's for the same,
For the
subject matter.
For the same course of action. My lord, the entire public is have a huge grievance against the action of the chief because of that. And this person also, my lord, he also came forward and filed this application. And accompanied by another missed case number, page 170, Lord, can you see? Seeking for condonation of delay.
So all these were clubbed together?
It will club together. I'll come to that point, my lord. What happened is this, but after this, my lord, page number 174, my lord. The petitioner has informed the collector again that the suit are pending, my lord. Therefore, compensation should not be released to any of the party. Now, page number 175, the learned trial court, district council court, has dismissed that application, saying that there was no sufficient explanation for filing the application for recalling. So it was a dismiss. My lord, date of dismissal is, my lord, 7 June 2022, page number 176.
176.
My lord, 76. Immediately, my lord, within a limitation time, page number 86, 186, they prefer an appeal, first appeal before the district council court, and it is still pending. Notice was issued to the chief, my lord. That is page number 186. 186. And later on, my lord, page number 210. The missed case, my lord, filed by with the petitioner case number 14 was also dismissed, my lord. Page number 210. And the date of the order is, my lord, available in page number 214. 214. It was dismissed, saying that there is no sufficient explanation for filing the application for recalling. Now, what happens is this.
For recalling or for condonation?
My lord, filing an application seeking for condonation of delay, for filing the application for recalling of the compromise decree. And thereafter, my lord, the petitioners here, they came to know that the respondent number 2-3 has withdrawn the compensation from the collector office. Now, therefore, they put up an RDI application, and my lord, kindly see that application is available, page number 251. 251 is RDI application, and the reply was given, my lord, page number 253. Reply was given by the office of the PIO of the collector. Now it says, number 1, the amount of land compensation which was sanctioned for the lands which falls under the Himalayan is 14 crores. Number 2, there is an application with the judgment and order dated 17 November 2022 passed by the learned judge, court of the Judge District Council Court. It's a dismissal order of that condonation application. Release to the management board, such. Now this management board was constituted by the Langren chief as well as his mother. And this body is headed by him, and they are managing this entire land. Now, 14, my lord, the release days of release is released on 23rd December 2022.
So?
Now, this collector has released the amount. My grievance is that, my lord, collector is a party in a suit where the suit land falls within the same area, the earlier suits. Number 1.
Suit which land was apparently acquired.
Yes, abundantly, okay, yes.
On
the stretch of land, my lord. Stretch of land passing through.
stretch of public highways passing through the entire suit length in terms of kilometers, my lord, kilometers. Now, TC was contesting, number one. Number two grievance is that he did not inform the petitioners that the other person come up for application for withdrawal. It is his duty to inform. He did not inform. He did not inform. And secondly, my lord, the first appeal was pending before the trial court. Now, during this, my lord, the respondent chief orchestrated the entire proceedings, taken a ransom, and withdraw the, my lord, the compensation. Now, compensation was withdrawn on 23rd last year. Now, I'm unable to file the miss case for stay because he has withdrawn already. Now, my humble prayer, my lord, the law is very clear. Lordship is very clear. Land Acquisition Act. The moment collector comes to know that there is a dispute, title disputes, it is his duty not to release it. So the first appeal pending, second, in the second suit, where he is also a party, filed at WS. Therefore, my grievance is the action of the collector is highly arbitrary. In fact, it was, my lord, withdrawn by the respondent chief by playing fraud. My lord, recently, 2019, a Supreme Court order is very clear, land acquisition case. Supreme Court held that if the compensation amount is withdrawn by playing fraud from the collector, it is the duty of the person to refund back. Supreme Court judgments, I'll place it later. Therefore, my humble prayer today is, Lordship may kindly issue notice. My friend is waiting for the collector. Other two respondents, my lord, I may be allowed to take a dusty service also. And Lordship may make an observation that they may be paid to dispose of at the admission stage.
We'll see. The affidavit have yet to be filed.
Yes, let them file affidavit immediately.
It's coming for the first time today.
Heard Mr. H.L. Sangrisul, Leonard Senior Counsel, appearing for the petitioner. The respondent number one, collector, Southwest Khasi Hills, Mokorat, has accepted notice through Mr. S.N. Leonard Senior G. As prayed for, let notice be issued upon the respondent 2 and 3 respectively, the same returnable within 2 weeks. In the meantime, the respondent number 1 is at liberty to file the counter affidavit in this case. List accordingly.
Madam, Lordship may allow me to take a personal dusty service. In the appellate suit, they are avoiding the proceedings.
You take steps in the usual form.
Yes, and I'll file the
you
service
take steps in the usual form because that is, the mode and manner of service of notice is already there. What happens is, as and when the report comes, then we'll see. You are at liberty to file your affidavit of service and all those things.
Item
number 5.
This is those DCRG benefit cases of
Yes.
DCRG benefit cases, my lord, and your lordship has
You are appealing for MECL?
MECL.
Excuse me.
State your lordship has asked for certain instruction in this matter, that what has happened and what is the position, my lord. I have got a list of the employees who are claiming DCRG and leave encashment benefits, my lord. May I please this list, my lord? And this,
We are, I think, as Mr. Sen has submitted, we are on the ground that this DCRG and leave encashment has been sanctioned.
yes, your lordship.
So
I just
what
want to
happens?
show the list of the list that it has been sanctioned for. This total amount is 750 crore rupees. And kindly see the list, my lord.
Yes.
List starts from page number 1 is, my lord, 13 cases, 13 writ petitions are there. In all 13 writ petitions, the amount has been sanctioned, my lord. Then your lordship will see petition number 1 at serial number 13. At page 13, your lordship will see at page 13 of the list.
Page
13, 1-3, my lord. And
Yes.
serial number is 611.
Yes.
And your lordship will find petitioner 611 is D. Swahalang, and his amount has been sanctioned on 10/1/2022. And if your lordship will see, the list is there beginning from page 3. Page 3. These are the pensioners who are also waiting from list page 3, my lord. Page 3.
Yes.
Page 3, your lordship will see 2015, then serially in chronological order, the list has been prepared, my lord. And if your lordship will see at serial number, page number 13, your lordship has seen, and this is with regard to leave encashment, my lord. And then there is another, my lord, page 25, same petitioner, at serial number 529, my lord.
Page
25, 25, my lord.
Yes.
Serial number 529. Petitioner, my lord, is there at serial number and your lordship 529, and the sanction date is 23/2/2022. So the sanction letters are already there, and at the end of the page, if your lordship will come at page 28, the total amount, if your lordship will see,
Yes.
the DCRG benefit 662 crore rupees, and and total amount is 749 crore rupees for all employees of MECL. So the scheme which has been evolved, my lord, and this scheme is being examined by Justice Thank You in a number of cases, my lord, and Justice Thank You has asked the MECL, my lord, to place the orders and place the scheme how the MECL will disburse the amount, because if the petitioner is at 521 and person who is waiting at serial number 1, then 521 can't still march over serial number 1. So this issue came up, and all these matters are pending, my lord. If I can pass those orders passed by Justice Thank You in please, excuse me. At this matter is similarly situated with other matters to be listed on 15th March. I'll list this matter on 15th March. Now on page 2, my lord, respondent has submitted before the court the total financial implication to clear the dues of employees of outstanding amount of DCRG is over 600 crore. He prays that he may be allowed to bring on record fact sheet on the exact number of employees and amount which has to be involved. Prayer is allowed, and they list the matter on 5/4, my lord. And then, my lord, all these matters, if your lordship will see page 4 and page 5, these matters are now listed time to time, and finally it is listed at page 7 is on 23rd June, where we are making an endeavor to clear the amount, but we do not have fund as of now, my lord. And similar cases have come up in various other high courts, my lord. I wish to place reliance on the order passed by Honorable Chief Justice of Meghalaya High Court as Judge of Calcutta High Court. The similar issue came up, my lord, that how do we clear the dues of employees, and then there the Honorable Chief Justice sitting singly held that the payment has to be cleared in order of in chronological matter, because petitioner is in 2022, my lord. Petitioner and those who are not before your lordship are waiting since 2015. So that is why Justice Thank You is seized with the matter. He is trying in all 7-8 matters. If your lordship will see the numbers at page 1 of the serial number, these are the petitions pending before your lordship. And Justice Thank You is seized with this matter, and he is trying to, by various order, he is trying to put pressure on the MECL, because as your lordship is aware, we are in dire state. NTPC is claiming 500 crore rupees. We are having the MSCRC, we are facing with MSCRC. MSCRC is not adding these costs as part of tariff cost, my lord. May I place this order of Honorable High Court of Calcutta? In similar situation, this order came to be passed. The grievance of the petitioner, paragraph 3, my lord, is that though the second petitioner father died in harness in 2009 and later was issued by the employer to petitioner on December 27, 2010, seeking second petitioner consent for temporary employment to be given to say, and petitioner have notified the second petitioner's consent, respondent have taken no steps to matter. It is submitted on behalf of Calcutta Tramway Company that since there are heirs of several employees who have died in harness, a committee has been constituted to look into the propriety of various claims and for processing application. The respondent company says that in accordance with decision of the committee, all persons would be called in order of seniority. In view of the submissions of the respondent company is disposed of by directing the respondent company to consider the respondent's candidature in accordance with the second petitioner's seniority as to the date of the application and not to allow any person who has applied subsequent to the petitioner to jump the queue and obtain any assignment ahead of the petitioner. So my submission is, my lord, that I have placed the list where there is a queue which we are maintaining, my lord. And Justice Thank You is already seized with about 13 writ petitions where various claims are there. And Justice Thank You has passed the order that we have to place the scheme and we have to place how we will disburse this amount, leave encashment amount. So therefore, my lord, my humble submission is that let all these matters be placed before Justice Thank You. He is monitoring it, and whenever we will get fund in order of seniority, we will disburse the amount to, because this amount of 700 and odd crore is huge amount, and therefore those who have come to this honorable court, they can't take march over the others who are also waiting for the amount 2015. So then, and there are other writ petitions, 13 writ petitions are pending on same issue. So in my submission, my lord, we will try to clear it, but as and when we get the fund and in chronological manner, in order of claim of the each party, because the claim I have shown, my lord, that the claim of these petitioners are of 2019, 2020, but still we have not been able to clear the dues of those who are waiting since 2015. So they are ahead of the petitioners, and therefore, my lord, let this matter, all these matters be tagged together, and at the order which I have already shown, my lord, that list has to be given, scheme has to be given, how to clear these amounts and how much time we will actually require depending upon availability of money. So,
Yes, I think Mr.
Yes, my lord, I'll make my submissions. I'll make my submissions in this. My learned friend has finished medicine. I'll make my submissions. No, my lord, this is very small. Facts are very small, my lord. The writ petitioner, my lord, he retired way back in January 2022, your lordships. Now, thereafter, my lord, sanction notices were issued so far, my lord, DCARG is concerned, number one, and the leave encashment benefits. Now, my lord, I have filed this writ petition, my lord, relying on a interim order passed by this honorable court on an earlier occasions. Now, if I can take kindly, my lord, if your lordship is holding the writ petition, my lord. Page 19 of the writ. Page 19 of the writ petition, your lordship.
Yes.
Now, Well, hard such and such appearing on behalf of the applicant submitted the pursuant to the admission of the main writ petition, prayer is made for grant of interim relief as far as the release of the amount of the terminal benefit due petitioner is concerned. There is the DATCAM retiral benefit and the leave encashment benefit. In this regard, the reference has been made to communication dated such and such, authorization dated such and such. Now, next paragraph, Lordship will note, Mr. Sahai, learned counsel for 219, has, however, submitted that he may be allowed to seek instruction in this regard, for which time is grateful. In that case, also similar submission made, my lord. The series of cases are pending, etc., my lord. They need time for instruction. Lordship looked into it, recorded it, ignored it, my lord. And thereafter, Lordship has directed, my lord, on the main consideration, the sanction amount. Sanction amount is always against a available fund. On consideration of the prayer made, the respondent authorities are hereby directed to comply with their own direction as far as sanction of discharge and leave encashment due and payable to the petitioner is concerned. The whole exercise is to be completed within 2 months. That was your Lordship's direction, my lord. Now, what happened, my lord? If they were aggrieved by this, they would have sought a review of this order before, my lord. They have never. They could have preferred an appeal, my lord, if they had a problem, formulate a scheme, etc., etc. They had never. In compliance of this order, my lord, they had disbursed the entire amount. And there, in that case, your Lordship, some of the writ petitioners, there were 3 writ petitioners, at least 2 writ petitioners, my lord, retired later than this present writ petitioners, after this writ petition. Now, they did not have a problem that you should stand in a queue and the court should revise its decision. Well, never. They have discharged it. So, whatever they are saying, my lord, this is just to avoid, my lord, the rightful entitlement. Now, my lord, in this regard, my lord, I will point out one decision, my lord, of the honorable courts as regarding, my lord, judicial discipline and committee, my lord. What it say? One thing, consistency of law is to be maintained. Number 2, law is to be predictable. No, what it mean by law is to be predictable? If in a similar situation, some kind of order is passed, so it is expected, my lord, the similarly situated person, if approach the court, a similar order will be issued to them. Suppose in this case, my lord, refused to pass an interim order, only on the basis of the submission, the other writ petitions were pending. Lordship will take note. In the other writ petitions, my lord, their main prayer, general prayer was, my lord, revised, my lord, the remaining of the revised pay scale. This was not disbursed. My prayer is also here revised pay scale. But, my lord, I am not seeking any interim for that because this is not yet sanctioned, perhaps. But as regarding the sanction amounts, my lord, based on an earlier decision of this court, my lord, which was duly complied by the MCL, I am making my prayer. Now, my lord, predictable, as I said, my lord, it means, Lordship, if in a similar situation it has been passed, then the similarly situated people, if they approach, my lord, has to be passed. Otherwise, this will lead to confusion. So, my lord, in this regard, my lord, I have given a list of books. And Lordship will keep it in mind, my lord, the batch of writ petition referred by my learned friend, my lord. No miscase has been filed. Nobody has pressed only release of the sanction amount. That was not pressed, Lordship. Now, my lord, if I can take your Lordship to page, my lord, this starts, the decision starts from page 396. Lordship has got it?
Yes, yes.
Relevant part, my lord, paragraph starts from paragraph 18. Paragraph 18. 1. Just 2-3 paragraphs, my lord.
Yes.
But I just say, it would be difficult for us to appreciate the judgment of the High Court. One must remember that pursuit of law, however glamorous it is, has its own limitation on the bench. In multi-judge court, the judges are bound by the precedents and procedure. They could use their discretion only when there is no declared principle to be found, no rule and no authority. The judicial decorum and legal propriety demands that where the learned single judge or a division bench do not agree with the decision of the bench, coordinate jurisdiction, the matter shall be referred to a larger bench, this submission. Now, my lord, here apparently, because I am confined today, my lord, only to the interim, Lordship already has a guidance in the nature of the interim order passed by my lord in earlier occasion, and Lordship will keep it in mind. That order was implemented. They never came before the court and said, sorry, there is a scheme standing in the queue. They never said. Nor they have gone for an appeal. They have complied with. They have discharged within that stipulated time. So when a guidance is already before my Lord, Lordship will not take a decision otherwise. Lordship will be guided by that. Because suppose, my Lord, what happens? Refuse to pass an interim order similar to one Lordship has passed earlier, which was duly complied with. What will happen? This will lead to a serious discriminations. Because, my Lord, admittedly, my Lord, those writ petitioners, some of them retired after me, this present batch of writ petitioners. Now, they have been disbursed with the amount, but if your Lordship refuse, the same would not be extended to me. That means, my Lord, my fundamental right guaranteed by, my Lord, Article 14 will be seriously violated. Now, I will come to the next page, your Lordship. Next paragraph, my Lord. This is quoted from some Supreme Court judgment. We have noticed that, with some regret, that when the earlier decision of two judges of the High Court of the origin case was cited before the learned single judge, my Lord, this is not very relevant. That is regarding a judgment to be referred to a full bench when disagreed. My Lord, I will come to paragraph 21.
Yes.
In recent decision, stress the need for a clear and consistent enunciation of legal principle in the decision of a court. Speaking of the Constitution when such and such, the doctrine of binding precedent has the merit of promoting a certainty and consistency in judicial decisions and enable an organic development of law. Besides providing assurance to the individual as to the consequence of transaction forming part of his daily affairs, and therefore the need to clear and consistent enunciation of legal principle in the decision of the court. Cardus pronounced similar thought with more emphasis. I am not to mar the symmetry of legal structure by introduction of inconsistencies, irrelevancies, and artificial exception unless for some sufficient reason, which will commonly be some consideration of history or custom or policy or justice. Lacking such reason, I must be logical, just as I must be impartial and upon like grounds. I will not do to decide the same question on way between one set of litigants and opposite way between another. My Lord, this strictly cover my case. And next paragraph is very important, your Lordship. In our system of judicial review, which is part of the constitutional scheme, we hold it to be the duty of the judges of superior courts and tribunal to make the law more predictable. You might not hear what I have said. Predictable means what, your Lord? Similar set of people given a relief. Obviously, the other people, my Lord, they are watching it. They will expect the same relief from the court, unless that order has been revised or a review has been sought. The question of law directly arising in the case should not be dealt with apologetic approaches. The law must be made more effective as a guide to behavior. It must be determined with reason, which carry conviction within courts, profession, and public. It matters, my Lord, how the people will think if it is refused. Otherwise, the lawyers would be in a predicament and would not know how to advise their clients. Exactly, my Lord, I will confront this situation. When these people came, my Lord, they are holding these orders. This is an order passed by this court. This has never been challenged, implemented. And in fact, those people retired after me. Why the same order should not be extended to me? So, my Lord, here the Supreme Court has taken note of this. Subordinate courts would find themselves in an embarrassing position to choose between the conflicting opinion. The general public would be in dilemma to obey or not to obey such a law, and ultimately falls into disrepute. So, my Lord, this has clearly said, my Lord, when an order is there covering a particular field, if the similar people are approaching, unless it is revised. My Lord, what stopped MJCL, my Lord, seeking a revision of this order or seeking a review or filing an appeal? They have complied. Now, when I am seeking for a similar relief, my Lord, now they are coming and they are saying, my Lord, number of batch of writ petitions were filed and all. They have never pointed out these things. So, my humble submission, your Lordship, I am squarely covered by this case, and Lordship is fully aware what is sanction amount. Sanction amount, my Lord, against the available fund. Now, if this available fund has been misused, my Lord, for that, my Lord, they deserve no mercy, no indulgence they need. So, my Lord, it is a case where your Lordship will interfere, my Lord, and Lordship will not deviate from the earlier order passed by your Lordship. But that will lead to serious discrimination.
Yes, sir. Now, your Lordship, if I summarize the argument that your Lordship has given interim relief on the earlier occasion, therefore the petitioner is also entitled to similar interim relief. That is the crux of the argument. And if your Lordship will kindly see your Lordship's interim order, which has been read out just now, my Lord. Your Lordship's interim order was in a fact situation where all the facts were not placed before your Lordship, that how many petitioners are waiting in queue. And that interim order is not a ratio or law laid down by this Honorable Court, which will have the binding precedent. Now, once all these facts have been placed before Justice, thank you.
What stopped the respondent at that point of time?
Yes, Your Lordship.
To point out to this court
Your Lordship,
the fact situation.
Yes, I'll answer this. I will answer. Now the question is that this judgment is, or this order of your Lordship is being treated as binding precedent, and therefore the orders passed by the coordinate bench are not binding precedent. In before coordinate bench, the argument is that none of them have sought interim stay. That none of them have sought interim stay. I don't know. They have got the petitions where everybody has. That statement has been made, which is incorrect on the face of it. Everybody has sought. Your Lordship knows that in these matters they seek miscellaneous relief. But my friend has made off the cuff statement that there is no miscellaneous application. So to that extent, my Lord, now your Lordship, once the magnitude, because on that day when the interim order was passed, my Lord, it was passed on the very first, this order was passed on very first day. The counter, when we realize the magnitude of the problem, my Lord, and that is why if your Lordship will say at page 2, when coordinate bench of this Honorable Court, asked the page 2 of my orders, the compilation of the orders. If page 2 your Lordship will see,
yes,
has submitted before this court the total financial implication to clear the dues of employees of the outstanding amount of DCRG is over 600 crore. He prays that he may be allowed to bring on record a fact sheet on the exact number of employees and the amount which will be involved. So now there is an order by coordinate bench taking a view that everybody will come in queue. What is the equity and good conscience, my Lord? Equity and good conscience that everybody will come in queue. And everybody will get their amount as per the chronological list maintained by the MSCRC, and that is the view taken by all high courts. Even this judgment, my Lord, I will refer to this judgment, whether this order of your Lordship is a binding precedent in for all cases. Because what is precedent, my Lord? Precedent is what it actually, the issue is the law. Whether your Lordship has decided any law that no, the once amount is sanctioned, it has to be paid. And the other argument which is being advanced, my Lord, is that once it is sanctioned, fund is there, my Lord. Your Lordship is aware that having fund is a separate issue and sanctioning is entitlement as per your service. That is why petitioner is before your Lordship saying that I have served and therefore I am entitled. And therefore the question which falls for your Lordship kind consideration is whether petitioner in view of your Lordship, that's the only fulcrum of the case, is the interim order passed by your Lordship. And there are interim orders passed by the coordinate bench, not granting the benefits. There are two sets of interim orders which are passed, my Lord. One.
No, Mr. Kumar, see, then you have to lead this court to the facts of those cases, or
I will place,
or you point out.
I'll place that all. Kindly see what is the interim relief which he is seeking. What is the interim relief? Please kindly see. What is the difference between interim relief and final relief? What has been sought in the final relief is the interim relief. If interim relief is allowed, his final relief is allowed without filing reply. Your Lordship, whether at the stage of interim relief, whether final relief can be granted. Your Lordship, kindly see the interim relief. What is the difference between the interim relief and final relief? To forthwith release the amount being death cum retirement gratuity and remaining 50% of the leave encashment as sanctioned on so and so date. And kindly see the final relief, my Lord.
48%, my Lord, that also your Lordship will do. 48% of the area.
Yeah, your Lordship will see the benefit, same relief. What remains in the main writ petition, if the miscellaneous application is, whether you get the benefit, the question is, you are entitled to get it in accordance with law or not. Secondly, if you are entitled to get whether the corporation is in position to make the payment ahead of all other claimants. Now, therefore, what my learned friend is saying is that give me the amount in terms of interim relief. We will place all the materials which has fallen from your lordship, that how this case, because if I read this citation, my lord, and I have read it, and kindly see the paragraph where the court says that if their facts, situations are different, then the orders can be different. And kindly see what is this order, my lord. This is the judgment rendered in final case. I'll just place the facts. Page 2, your lordship, the fact which are of central importance. Because the judgment is an authority, what it actually decides, not what follows from it, my lord. And kindly see what is the fact. Facts which are of central importance may be stated as follows. On June 19, 1982, Government of Maharashtra issued a draft notification under 3.3 of so and so, my lord. So this is a case involving draft notification, which was, my lord, set aside, and then thereafter the Honorable High Court, where the relevant paragraphs have been relied upon, my lord. Kindly see. The relevant paragraph, paragraph 17. Paragraph 17, third line, my lord. The learned judge directed the government to publish again a draft notification for reconsideration of the matter. They gave liberty to writ petitioners and intervener to submit their representation. They observed that this is a fit case where parties should be given reasonable opportunity of being heard. Kindly see the facts of the case. They did not quash the impugn notification but told the government to make necessary changes in the light of fresh consideration. All these directions were issued after recording the positive finding that exclusion of Ulhasnagar from corporation was arbitrary and irrational. The net result is that there is now no discretion with the government to keep Ulhasnagar away from corporation. It would be difficult for us to appreciate the judgment of the High Court. Kindly see the context, my lord. One must remember the pursuit of law, however glamorous it is, however own limitation on the bench. A multi-judge court, the judge are bound by the precedents and procedure. They could use the discretion only when there is no declared principle to be found and no rule, no authority. So your lordship there has to be declared principle. And there has to be declared principle, and if that principle is not followed, then the petitioner can claim. Your lordship, while disposing of the writ petition on very first day, while passing the order, your lordship has not declared any principle. Only said, petitioner has come, his sanction amount is there, you give him the money. I have shown the chart, my lord. In chart, there are the 750 crore is due to more than 1,000 employees, my lord. Now, if that precedent has to be followed, the precedent is only, the law has to be declared, no declared principle. So there has to be some principle that look, in case where the amount is sanctioned, the employer is bound to release it. And in my humble submission, my lord, I do not see the principle. That was an interim order. An interim order has been given the status of the order which is in the nature of final. It is an interim order. So, and then your lordship will see next, the judicial decorum and legal propriety demand, where a learned single judge of division bench does not agree with the decision of bench of coordinate jurisdiction, matter shall be referred to larger bench. Now, there has to be some principle. I have placed 7-8 orders, my lord, which my friend is also aware, that in those orders, my lord, the antical issue is pending. And those writ petitioners have come before the present writ petitioners, my lord. Those have come. Now, what my friend is saying, that there has to be judicial consistency. Now, I have shown 7-8 writ petitions, orders where the learned single judge of this honorable court is seized with the issue. And he is trying to ensure that the payment is made in equity, in good conscience, in orderly manner. Now, what my friend is relying on, that one interim order where the writ petition was disposed of without laying down any principle of law. If the principle of law would have been laid down, my lord, my friend is right, we would have approached this honorable court for review, we would have gone in appeal, but no principle of law is laid down. Sometimes the orders are passed, you give him relief, but when entire magnitude the condition of the MECL and the fact that all similar writ petitions are pending before your lordship, where the identical issue is placed, including they are all seeking interim relief, are all of them are similarly situated. Why should the client of my friend be entitled to different treatment? Because, and the basis of the whole argument is, there is an interim order which is not laying down any principle. And the whole judgment of the Honorable Supreme Court is that once principle is laid down, and what is the principle laid down here, my lord? In the court, it is said that the order passed by the High Court, by the state government, is that it was bad in law. And then thereafter, relief was denied. So in that case, principle was laid down. And in that fact situation, the Honorable Supreme Court said that judicial precedent is binding affair. So therefore, in my submission, that interim order cannot be exalted the status of interim order giving final relief. At the interim stage cannot be given exalted status of laying down the law. That in all cases where sanction amount is there, this will be done. And you also will see at the orders which I have placed. Now the 50%, in the other cases also, my lord.
Where?
Page 7, my lord. Page 7 of this the compilation. Learned counsel for the respondent submits that for some writ petitioner, 50% leave encashment has already been settled, and for the remaining dues such as DCRG, petitioners have been offered payment in 6 months. He is directed to bring on same record by way of affidavit to enable the petitioner to obtain instruction. That is on now. The matter is listed for hearing on 23rd June. I would be praying, my lord, all these matters, because then your lordship will be flooded with all 10,000 or 6. The list is long one, my lord, saying that so and so has got the relief by interim order. I am also entitled to get it. Then in that case, corporation will be shut down, my lord. We do not have money. If we were having money, we would have given the money. And this kind of situation keeps arising, my lord. So therefore, in my humble submission, my lord, let all these matters be tracked together, because issue is common, point is common, payment demand is common, my lord. And this should be consistently dealt by your lordship on 23rd June.
Yes, my lord, I'll make some submission. Firstly, your lordships, so far the judgment is concerned, my lord. The judgment I refer to paragraph 18 onwards. So for paragraph 18 onwards, my lord, this deals with the general principle of law, my lord. Independent of any facts, they have referred to earlier decision. What they have categorically stated, my lord, what should be the general proposition of law, my lord, in the matter of judicial discipline? One is consistency. Another thing is, your lordship, law should be predictable, my lord.
As far as principles are concerned,
Lordship.
I mean, it is, you have made a point,
Lordship.
well settled. There's no quarrel with that.
But so that's what I am reminding your lordship. So this is the general proposition of law.
The only thing that is required here is how do they fit into the facts and circumstances of your particular case.
I am coming. I'll just give you some brief answer. Now, my lord, this is the general proposition of law, and lordship has accepted it. These are the law is to be followed, is binding. Now, my lord, coming to that interim order. Now they are saying so many things, my lord, the roster should not jump the queue and all. When that order was passed, my lord, after hearing them, that order was passed. My lord, they have no point of time they sought a review.
You have that also. You have
my lord, what I am saying, they have disbursed the amount. They have disbursed the amount. Now they are saying, my lord, making a hypothetical statement that if your lordship grants the interim order, will be flooded. These are absolutely hypothetical statements. See their conduct, my lord. Are they serious about it? Had they been serious, my lord, they would have preferred an appeal against this order. They have complied with it. My crux of the issue is this, my lord. They have complied with an order, interim order, which was never revised, still holds a precedent, my lord. And this is a only guidance before your lordship. When, my lord, similarly situated people have come before my lord, seeking for similar review, lordship cannot refuse. If your lordship refuse, my lord, you amount to what, my lord? Amount to, my lord, lordship debating from your lordship's own directions, number one. Number two, my lord, this will lead to, my lord, serious discriminations. The first batch of writ petitioner who came, lordship has granted them the interim relief, and they have availed the relief, they got it from the MECL. Now the second batch who are similarly situated, my lord, if it is refused, that will violate the fundamental right, my lord, Article 14. So my humble submission, my lord, this is a case, my lord, where lordship need to pass. Otherwise, my lord, when it will go against the settled principle, my lord, laid down.
Fine. So I've heard the parties.
Yes, Your Lordship.
I'll pass the orders.
Yes, Lord.
Really costless. Item number 1.
.482 matter, my lord, we'll take up after the lunch break.
What is
My lord, the issue only is that, my lord, section 307, attempt to murder, has been charged. So, can on the basis of
son-in-law and father-in-law?
Yes. So that is only, even in fact the state also has raised an objections only on that 307, can it be compounded or not?
Mr. Shula, I said
That's the only issue.
you will bring some authority on that?
Lordship, but not today, Lordship. We will do on some other day, Lordship.
My lord, that's my
Some
lord.
other day, Lordship. I have the authority with me.
My lord, yes.
But not today, Lordship.
Any day, my lord's convenience, my lord. As per my
1 week, 2 week?
a week's time, my lord. In a week's
After a week, we'll do your
my
Lordship.
lord.
We'll pre-meet by the parties. This is matter after 1 week. So 1
Apply
week.
your Lordship.
May I make mention of item number 18, my lord?
Just a moment, let us finish with the
my lord,
other portion first.
Item
Because in
number
any case, if there are urgent matters to be heard from the hearing list, it has to be taken up after lunch. So as of now, if there's anything, you can mention it. Let the auto portion be finished first.
Item number 2.
Yeah, anything was
Item 4, which is next in the list.
yeah. This is only for filing of your.
Written argument is filed, my lord.
Then what?
When will be posted for which item? Orders.
When have you filed? Today?
I filed this morning.
Learned counsel for the state respondent has, learned G appearing for the state respondent has submitted that the written argument has been filed. All the parties have.
Yes, ma'am.
Are there any independent? No. I mean, no respondents, private respondents are not there.
Union of India is a party, my lord, but
Yes. What?
For me, I'm not used to add anything other than my opinion.
Okay. So you are not filing your written argument. Accordingly, matter is now posted for judgment. So reserve of judgment then? Yes.
Item number 18, my lord, was my friend Mr. Sen is there. The other side. This
So?
matter, my lord, we taken up after a week, my lord. It's
20 matter. On pre-made by the petitioner, this is matter of 2 weeks.
2 weeks. Obliged.
My lord, item 12 of the hearing list, my lord. Now, my lord, here I am for the petitioner. My lord, the rejoinder has been filed today, my lord. So the matter may come up for hearing after 2 weeks.
Your Lordship, we have the respondents.
On pre-made by the petitioner, this is matter up to 2 weeks.
Your Lordship, item 21, Your Lordship. Your Lordship, this is a case under section 482 CRPC for quashing of the FAR. Your Lordship, it has been charge sheet has been filed, Your Lordship. So, Lordship, if I may be allowed to withdraw the petition, Your Lordship, with liberty to file the fresh one.
It is up to you. You can file or you can, you choose not to file. The onus is on you. Learned counsel for the petitioner has submitted that the petitioner may be allowed to withdraw this petition. On submission so made, the petition is dismissed as withdrawn.
Item number 11, my lord, I'm appearing on behalf of the respondent, my lord. Here, my lord, both the parties were supposed to file the written argument, my lord. If some more time may be granted, my lord.
Who is for the
Sajha.
on pre-made by the respondent, this is matter after 2 weeks.
Much obliged, my lord.
So we are left with how many matters to be taken up? 1, 2, 3. Slightly, ne? Huh? Hardly. So we'll take up the matter after lunch then? At 2:30?
Item number 13.
Lordship, in this matter, Lordship, Mrs. N.G. Shilla used to appear for the petitioner, Lordship.
Yes.
Now she's no longer appearing. On the last date, Lordship, if I'm correct, her junior came to appear. Today also, but she did not come today.
No, I think last date this order of this court is for the registry to issue notice upon the petitioner. Notice has been received.
Has been received.
Petitioner is not here.
Petitioner is not.
We'll wait.
We'll wait.
In terms of the order of this court dated 9/5/2023, whereby the registry is directed to cause notice to be issued upon the petitioner, informing him of the fact that his counsel has since ceased to appear on his behalf in this case, and for necessary steps to be taken. The office report would show that the said notice has been received by the petitioner. However, the petitioner is not present today. Accordingly, let the matter is adjourned to allow the petitioner to appear for this court. This matter after 2 weeks.
Obliged.
Item number 20.
Yes, miss. But who's the appeal respondent?
Yes, here. Just mathematic. Revision petition is filed for setting aside the judgment and decree dated 2017.
Yes.
Passed in title suit number 9 of 99 by the subordinate district council court, Shillong, Lordship, and subsequent order of warrant of execution dated 3/12/2018, passed in execution case number 3 of 2018, Lordship, whereby the petitioner was in possession of the property. She was dispossessed from her possession. I have filed this petition for not on merit of the case, not for merit of the case.
Yes.
Lordship, it is like an appeal, but I have filed this petition. There is a gross irregularities and manifest error of law. That is why I filed a revision petition, because earlier in the suit, Lordship, I was not a party to the suit. Defendant, private defendant, opposite party herein, the defendant, defendant number 3 of this, respondent number 1 and 2, they have instituted a title suit before the learned subordinate district council court, Shillong, airing, Lordship, that defendant number 1, who during the proceeding expired. I will come to that point, Lordship. Annexure 1, 76, Lordship, kindly turn to, this is the plaint, Lordship. Annexure 3. Page 76.
Page 70.
76.
76.
Lordship, there are 3 plaintiffs.
So this is the initial title suit.
Initial title suit filed before the learned subordinate district council court.
Yes.
There were 3 different plaintiffs, Lordship,
Yes.
and they added Promuel Lindo, Lordship, at that time,
Yes, yes.
subsequently, and U.P. Sinkley, secretary,
Yes.
and U.S. Lindo, both of Right Nongpo River district.
Yes.
They are the secretary of Right Nongpo. Against the order of village court, their suit was filed.
Okay.
In the title suit, Lordship, there is nowhere mention about the area of the land. Kindly turn to page 77, next
Yes.
page, Lordship.
Yes.
Here the boundaries of the
Yes.
land they have given, but nowhere they have mentioned about the area of land, how much land was there.
Yes. In this title suit, who are you?
Initially I was not a party to the suit, Lordship.
You are not party here.
I was not a party. After eviction, after disposition, I have come to, I was possessing the said land since
Okay, you are not a tenant also.
I am not a tenant. I was possessing the land
Possessing the land.
as per instruction of that defendant 1, and I have constructed house over the land in 1998, Lordship.
And what is the status of ownership of the defendant 1?
I am coming to that point. Subsequently, in 2003, she has purchased the land from defendant number 1. But during that period, she did not know about any litigation pending before the learned court. She was not informed by the plaintiff or defendant. In this case, on page 79, Lordship,
yes.
Plaintiff number 4 appeared before the Secretary Right Nongpo and applied for certificate copy. But here is no appellant.
Who's plaintiff 4?
Plaintiff number 4. There is no plaintiff number 4. Okay. This is the gross discrepancy. Despite knowing fully well about the discrepancies, the learned trial court accepted the plaint of the which was to be rejected at the time.
Yes.
And their prayer is for only for ownership and possession. Kindly turn to page 80, Lordship.
Yes.
Serial number 16. The plaintiff only prays for a decree.
Yes.
The plaintiffs are the owners and are in possession of the suit land for permanent injunction restraining the defendants from interfering with the right, title and ownership of the plaintiffs. This is their prayer. There is no prayer for recovery of khas possession. There is pleadings that we have been possessing, the defendant number 1 has been possessing the land. Despite knowing fully well about the possession of the land, the learned court below passed decree, judgment and decree on 2/27.
So after this title suit was instituted.
Yes, Lord.
So
defendant
has filed a written statement.
Written statement.
Issues framed.
Issues framed. Lordship, during pendency of the suit, he expired.
Okay, was he substituted?
Defendant number 1 expired.
Has he been substituted?
That was wrongly substituted. That was also wrongly substituted after 2.5 years. Without filing any abatement, suit was abated. Subsequently, after 90 days, that person was expired on 23/12/2012. And the counsel for the defendant also informed the Honorable Court, learned court below, that defendant number 1 expired. Only there is a statement. I will go through that point also. And subsequently, the court also stated that the suit was abated. There is an order that abatement of the suit. But without following any provision of law, after 2.5 years, when new advocate came, he filed an application for substitution. One of the legal heir of the deceased defendant. There are one son and three daughters of the defendant, leaving them apart, only mentioning the name of the wife of the defendant, Lordship. Then whole case is without jurisdiction after expiry of defendant or plaintiff in any case. I will go to that point also. Lordship, page 165. This is the judgment of the Honorable Court. I have annexed all the orders of the
160? 165?
Yes, Lordship. Last line, Lordship. Order dated 13/2/2013.
Yes.
CR put up today.
This one.
Lordship got it.
Yes.
Both parties are represented through the counsel. It is informed by the counsel for the defendant. The defendant number 1 was expired.
Okay.
Page 165. Lordship, then turn to page 163.
160?
Sorry, 168. I was showing only relevant portion. Otherwise, it will be very difficult for the court also.
Yes, only the relevant and significant portion. Otherwise.
I don't know.
165?
I don't know about it because I have filed long back. You have replied for that also.
No, this we are saying some requirement, no? Please do.
25/6/2014. 168.
168?
Yes.
Year
CR put up today, Lordship.
25/6/2014.
Yes. 25/6/2014.
You got it, Mr. Devnath?
Last. Yeah.
25/6.
Page 168.
168.
Order dated 25/6/2014.
CR put up today. The plaintiff is present today. The defendants are absent.
Yes.
As the defendant 1 was reported died since the 13 to 2013, but the wife of the deceased defendant have not come before the court for substitution. Hence, the suit against the defendant 1 is stand abated. How the wife of the defendant will come without substitution?
It is the plaintiff to take steps.
It is the plaintiffs to take steps to bringing all the legal representatives of the deceased defendant, and in case of the plaintiff, then it is the duty of the defendant, Lordship. Under Order 22, Rule 2, 3, and 9. 3, 4, and 9, Lordship.
Yes.
Then 9 to 15. Order dated page 170. 170. Sir, 9 to 15.
Yes.
Yes, Lordship. CR put up today, both the parties are absent. Seen the withdrawal petition 26/15 filed by the counsel for the plaintiff. This said petition hereby is allowed, and the Vakalatnama issue notice to the plaintiff. The counsel for the plaintiff also withdrawn their Vakalatnama, Lordship. Then same page, Lordship, order dated 23/4/2015.
Yes.
CR put up today, the plaintiff is present today and have executed new Vakalatnama by appointing SM kind as the counsel. The defendant are absent, let the plaintiffs take steps to issue notice to respondent number 2, defendant number 2 and 3, fix so and so. (171) page number. Next page.
Yes.
29/6/15.
Yes.
CR put up today, the plaintiff is present today, seen substitution petition filed by the plaintiff in place of, this is defendant number 1, by petition number 289/2015. Seen also the address of the defendant number 2 and 3. Issue fresh notice on the substitution defendant number 1, Srimati Siti Kongji. This is the order. Without any abatement of the, any application for abatement of the order of this learned court below, or condonation petition, and proper substitution of the deceased of the representative of the deceased. That application filed by the counsel has been was accepted by the learned court below. Then 31/7/2015.
Yes.
CR put up today, the plaintiff is present today, the defendant are absent, the defendant number 2 have since expired. Defendant number 3 also expired, Lordship.
Yes.
As reported by the process server. The defendant number 2 have received the notice, except defendant number 1 have not received the notice. I don't know the language of the court, Lordship. This is the language. Reissue notice to.
So that means defendant 2 has received notice, defendant 1 have not received.
Yes.
But substitution was directed, substitution was affected on defendant 1.
Defendant 1.
Yes. Reissue notice to Srimati Siti Kongji. That's defendant 1.
Yes.
Please continue.
Then, yes, Lordship, I am coming to that. 173 page. Next, right hand side.
Yes.
3/5/2016. The plaintiff is present, the defendant are absent. Seen the notice been received by the neighbor of the defendant number 2. I do not know about whether there is any customary practice like to give a notice to a neighbor.
Yes. So
then 6/6/2016. Next.
Yes.
CR put up today, the plaintiff is present, the defendant are absent. Since the defendants have choose to remain absent in spite of having received the notice issued by the court, hence the instant suit shall hereby proceed at ex parte against the defendant.
Yes.
Without looking into that whether a notice has been served or not, Lordship. I wanted to only see the manner in which the learned court below has passed the order. This is the anomalies, and subsequently order was passed on 2/2/17. That is page 174. Ex parte argument. Now, Lordship, kindly come to
Have you annexed the type copy of this order?
everything I have typed. Everything I have typed.
Where's the
Lord.
type copy of
Yes. Which one?
this 175?
No, 170. This is entire copy of typed from 76 to.
No, this is, you see, this is in written form. Sometimes might be difficult to read, no?
Type copy I have given, Lordship.
Type copy of this?
Yes, Lordship. That was a.
Where is it?
Yes, I mean, that is from page. Annexure 4. Totally. 132 page number, Lordship. Annexure 5, Kohli.
Just one.
Entire copy, type copy of that
Yes,
judgment, Lordship. I have an next original certificate copy, Lordship.
Yes, see, now you are referring to page 175.
Yes.
The order dated 31/5/2000, if I'm not mistaken. Anyway.
Lordship, got it? Huh? Page 132.
Just one.
Page 174. This is the type copy of.
This is a type copy of 175 to.
Just a minute, Lordship. I'm sorry for 132 279. This is the certificate copy.
No, what I'm saying is this. You see, this is your petition.
Yes, Lordship.
You look at page 175. This is the. It appears it's a certified copy.
Yes. Yes, Lordship.
But the certified copy is, it was photocopy. See, the order sheet was
Original
photocopied.
copy I have.
No, listen to me. The order sheet was photocopied, and that has been certified to be true copy and filed.
Yes.
That is okay.
Yes, Lordship.
But here, you see, this is the time when the presiding officer or the judge still writes the order by hand.
Yes.
He has written by hand, isn't it?
Yes.
So whatever we can read, we can read.
Yes.
Okay. But there may be portions where you can't read the written, the written form. The spellings, or sometimes the letters are too small. So it would be preferable if a type copy of this is.
This is the type copy, Lordship. That is 132 to.
Okay.
174.
Now tell me.
Yes. Letter.
Okay, because you are referring to page 175.
Yes.
Where is the corresponding portion of this in your type copy?
Corresponding portion of that original.
Yes. The corresponding in your type copy should be there.
It is every date is there, Lordship. I have mentioned every date of this. No, it is serially. It is not serially. Don't send like that. You have not mentioned that it is not serial.
Just a moment. Let me be clear.
Yes, Lordship. Kindly go to page.
Yes. I got it. Yes.
Lordship.
See, because after referring to your type copy.
Yes, thereafter I have.
Then you refer again to 175. So I thought it's a continuation of the.
Oh no, Lordship. That is the.
Yes.
That is annexure 5 Kohli. That is type copy. I have mentioned about the type copy. And.
That's okay.
It's okay. Lordship.
Please continue.
Everything I annexed, court also verified, registry of the honorable court also verified everything.
That is okay.
Therefore, I have came from Guwahati 5 times only for correction, this date, everything. Not like Guwahati.
Yes, it's true. But you should have.
But it is nice.
You should have at least engage a local council to help you with all this.
That time, actually, Lordship, I was in suffering from illness. Suddenly I have to come. We have not think about that. Local council.
But that would be much better to run around and do all these things.
Yes, Lordship. But I have corrected everything as per direction of the registry.
Okay.
Now the Lordship here, title suit, Lordship, defendant, one from whom I had purchased the land subsequently. Since 1994, I had been possession of the suit land, and I did not know about anything about the case pending in the learned court below. After disposition on 9/10/2019, Lordship, suddenly I inquired about the case. Then on 14/10/2019, I applied for certificate copy and received the copy on 15 next day, Lordship. And thereafter, the petitioner came to know about the case. The case is pending before the learned court below. At that time, I have mentioned in my paragraph 17, page 14, Lordship. Page 14.
15. 17.
Page 14.
Page 14, yes.
Paragraph 17.
Yes.
That from the certified copy of the orders, the petitioner for the first time on 15/10/2019 came to know that a suit being title suit number so-and-so were instituted by the opposite parties as plaintiff for declaration of right title, ownership and permanent injunction restraining the defendant from interfering with the right title and ownership of the plaintiff. Then except the boundaries of, there is no mention about the area of land, there is no address of the proper address of the plaintiffs, and there is no plaintiff number 4 mentioned in the plaint. No legal heir of Ojendra Lal Kharsandi was implicated in the suit. They have mentioned about that one Ojendra Lal Kharsandi was the owner, but they have not implicated any of the legal heir of Ojendra Lal Kharsandi in the suit also. Despite several inconsistencies in the plaint, this same was accepted by the learned court below and proceeded with the case. Lordship, then come to page 32, annexure 1. This is the judgment. It is also type copy.
Yes.
Original copy I have submitted before this honorable court. Page 35, judgment dated 2nd February 2017.
Yes.
Mention about every title, the plaints regarding plain, etc. I am not going to that. I will only show. Page 50, Lordship.
Yes.
Page 50, PW4.
Yes.
In the examination in chief, states, after the death of Dil Kharsandi, sometimes in the year 2000, Sri Nadrim Siamyong has been empowered by us to take care of the property in our behalf since I and my younger brother, Jesterwell Kharsandi, used to engage in some other activities in Shillong and other places. In the said PW4 in his cross-examination states that it is a fact that the suit land is not in my possession, in spite of the injunction order of the order, the defendant number 1 is still continuing with the construction works in spite of the status quo order. That means the defendant number 1 has been possessing the land when the suit was instituted thereafter also. Then, Lordship.
But you said that the defendant number 1 has sold the land to you.
That is why they have to mention who was in possession.
So they have assumed that
Defendant number
defendant number 1 is in possession.
Is in possession.
And he is the one who is doing the construction work.
But I do not know when they have given the chief examination was done, because I do not know about that.
You see now, defendant number 1 has been represented. He was.
I am representing now.
No. In the.
Yes, that time defendant number 1 he had filed written statement before the land.
So he was represented.
Yes.
He has not.
He had not mentioned.
Why did he not mention that the land was sold to you?
That was sold in 2003.
And this suit was instituted in
2019. Oh, sorry, 1999.
1999.
Yes.
So during the pendency of the suit, the land was sold to you.
Thereafter suit. During pendency of the suit.
During pendency of the suit.
Yes. Yes, I will go to that point also, Lordship, today.
Yes.
Just kindly, I wanted to show the order of the learned court below. Page 51, Lordship.
Yes.
As for the statement given by the plaintiff number 1 and 2, it is found both of them had admitted that this would land in possession of the defendant number 1. Even though the witness number PW1 and 2 have stated that they used to work and utilize the suit land, but the same cannot be taken as proved. Since the main plaintiffs have admitted that the possession is with the defendant, they have mentioned about the honorable learned court below also mentioned that I have the defendant number 1 in possession of the land. Next page, Lordship, page 52.
Yes.
Issue number 3, where they have stated whether the suit is barred by the principle of estoppel, waiver, and acquiescence. The plaintiff at para 10 of the plaint stated that the plaintiffs appeared before the Secretary Right Nongpo and applied for certificate copy of the complaint and contest the plea allegations after defendant number 2. The plaintiff number 3 produced the sale deed dated so and so, but the defendant number 2 decided and that the suit belongs to the defendant number 1 by the order dated 10 April 1999. That is the village court order.
Okay.
Below that, PW4 in the cross-examination states it is a fact that as per paragraph 10 of the plaint, the Darbar Right Nongpo had decided the suit land belonged to the defendant number 1 by the order dated 10th April 1999. Accordingly, to paper mark A, which is the order dated 10th April 1999, passed by the Darbar Right Nongpo, it is found that the said Darbar has decided the ownership of the suit land in favor of the defendant number 1 in their administrative capacity. Therefore, the said Darbar, which has exercised authority without adjudicating the same as per the authority of the competent civil court, hence the said order is hereby treated as null and void and not barred by principle of estoppel, waiver, acquiescence. Issue number 3 is hereby answered accordingly. How the learned court below has set aside the order of the village court or decision of the village court in a suit, Lordship. There is some provision
It has to be on appeal or revision.
Lordship.
It has to be on appeal or revision. If the said order is appealed against, you see, village court order has to be appealed.
Appeal. That is, they must file an appeal.
So
they ought
must
to
file
have
appeal.
filed an appeal
But
before
it has
the
not been
subordinate. They have filed suit, Lordship.
Yes.
The United Khasijantia Hills Autonomous District Administration of Justice Rules 1953, Lordship.
Yes. Yes.
Page 5, Lordship. Original book is not with me. It is just,
Do you have this copy of the order dated 10 April 1999?
they have annexed.
Do you have it?
They have annexed, Lordship. This is the, it is in page 88.
Just a moment.
That's what we get. 87, 88. That is the 10th April 99. Last line, Lordship.
Yeah.
The Darbar has passed judgment and order in favor of Sir Promuel Lindo in respect of his plot of land mentioned in the schedule above. Hence, the Promuel Lindo can use the land as he feels deemed fit and proper. Therefore, Darbar Rai Nongpo has passed the order that aggrieved party may appeal this judgment and order within 3 months from the date of this order.
Yes.
Under United Khasijantia Hills Autonomous District Administrative Justice Rules 1953, page 5, it provides constitution of the courts, Lordship.
Just a moment. Oh, that is okay. Constitution of the court is always there.
Yes, constitution of the 3 courts:
Village
court,
court,
subordinate, and district council.
Yes. That is,
And page
this
6.
This is the hierarchy.
Yes, Lordship. And village court constitute of who can pass the order.
Okay.
Page 6.
Just a moment.
Constitutional village court subject to the approval.
Just a moment.
Lordship. I have given all flag mark.
Yes, yes. This is chapter 2, rule 4.
Yes.
Yes.
Next page, Lordship, page 6. Village court, constitution of village court.
Yes.
Subject to the approval of the executive committee, there shall be a village court for each village, provided that 2 or more villages may together form the village court. Each village court shall be composed of the recognized Sirdar, CM, Raid, Boy, Basan, and Lindo, Lingscore, and headman of the village.
Yes.
Who can preside? Then section 11 of page 7.
Yes.
Regarding subordinate district council court and additional subordinate district council court. Then turn to page 12. Page 12, chapter 3, Lord.
Yes.
Suit and cases to be tried by village court.
Yes.
May I read, Lord?
Yes.
A village court shall try suit and cases of following nature. Cases of civil nature, provided that if any immovable property is in dispute, the property must be situated within the jurisdiction of the village court. And in all other cases, all the parties must reside or hold land within such jurisdiction. Both the parties are claiming land under the judicial revoid district. This is the suit property is in revoid district. That is why village court can entertain application of the any application from any of the parties, because matter relates to revoid district. Therefore, the village court is competent to pass order. And against that order also they have annexed that order in the suit.
Yes.
Their plaint. Then, Lordship, page 13. Section 16.
Yes.
Appeal to subordinate district council court and additional subordinate district council court. Subject to Rule 29, in appeal shall lie to the subordinate district council court or additional subordinate district council court, as the case may be, from village court within the jurisdiction of the subordinate district council court or additional subordinate district council court concerned. Then, Lordship, page 14, section 18.
Yes.
Subordinate district council court to try civil suits and criminal cases.
Yes.
Subject to rules 19 and 20 and 21, a subordinate district council court shall be competent to try all civil suit not triable by a village court, in which all the parties reside or hold land within the jurisdiction, and if any immovable property is in dispute, the said property is also situated within the same. This is clear, Lordship.
Yes.
The subordinate district council court cannot decide the suit where the jurisdiction of the village court is given in these rules. They mention about the everything details, Lordship. But they have filed the suit against the order of the village court before the subordinate district council court, which is without jurisdiction, Lordship. In last occasion,
But
Lordship,
you are not going to the. See, you are not going to the merit of the.
I am not going to merit.
So
I am only
that issue can be decided only when you question the maintainability of the title suit.
Which one, Lordship?
See, the issue of
any appeal, anything like
once
that.
you raise the issue of jurisdiction, then it has to be by revision or appeal before the appropriate forum.
Yes, it is only only jurisdictional matter. When there is no jurisdiction, the learned court below cannot pass any order. First, they have to file an appeal before the learned subordinate district council court. They did not file any appeal. But instead of that, they have filed a suit before the learned court, whereby the learned court below declared the order of the village court as null and void. Whether the learned court below can pass that type of order declaring that order of the village court is null and void in a suit. I am not stating about any appeal. They have not filed any appeal against the order of
Yes, that's us.
Lordship. Lordship, on 13/12/2012, during pendency of the case, the defendant one expired.
Yes.
Thereafter, the case was notice was served some of the party without impleading the necessary party of the legal representative of the deceased defendant, as per provision of law. And suit was proceeded ex parte. That was I have already shown before the court about all the cases. This is the main fact. Wherefrom I have come. I had been possessing the land since 1994. I have constructed my building in 1998. I got compensation from the deputy commissioner when the forelanding was that time. They have issued notice to the my client. Client, I have annexed it also, Lordship. That is in page.
No, first you have to show how did you come to be in possession of the land.
As per their advice, we have taken possession of the land in 1994. So how, defendant number 1, Lordship.
So how was it done?
Then we have
was it by way of a transfer, by way of a
that
sale?
Time, subsequently it was transferred. At that time, that was not transferred. There was some understanding between the parties. I don't know about 1994, but subsequently that land was transferred in 2003.
Oh, see, first by approaching this court,
yes,
without being a party before the courts below, you have to prove your bona fide.
No, because all the cases, there is no case now. I have been disposed as per by virtue of non-executable decree of the court. Because I am claiming my right in of defendant number 1.
Yes, and
who expired. I'll show that also.
No, that apart from that, you see, you have not been able to prove your bona fide or your title and ownership before the courts below because you were not
party to the suit.
Not party, and notice was not issued to you. Fine.
Yes, Lordship.
Now, on coming before this court, you have
it is revision petition.
You see, what you have done is you have placed all these things. You have assailed the impugned proceedings.
Yes.
You see, but now you have to prove your locus.
I have not come before this court for reappreciating evidence of that court.
Exactly.
Yes, Lord.
Even if you see, if you have come in any form
yes,
or manner before this court, you still have to prove that you have a right to come before this court.
Lord, that is why I am showing, Lordship, that everything. I was not well. That is why some difficulties. I think no.
If you want to
spinal disorder, I have been suffering. It is very difficult for me.
No, if you want to pray, you want to prepare, you can.
No, I am today. I have prepared everything, Lord.
It's up to you.
Only I wanted to show everything regarding the discrepancy in passing the order.
If you want to stop the proceeding here and continue next date, it's up to you.
No, Lordship. Today itself, if your Lordship.
It depends on you. If
Lordship is not exhausted.
No.
Since morning, Lordship is.
I'm here. You see, the court is always here.
Annexure 9 date. Annexure 9, Lordship 297. Page number 297 of the revision petition. 297, Lordship.
Yes.
Annexure 9. This is the sale deed. Dated
Date?
25th March 2003, third line, second line, Lordship.
Yes.
Sold to the plot of land measuring an area about 18,306 square feet, situated in Nongpo Downgate, and boundary was given and a consideration of price of rupees 2 lakhs. And 299 is in Khasi language, Lordship. Yeah. That is translated copy.
Okay.
Annexure 10, Lordship, page 300.
Yes.
1458, no objection certificate. This is to certify that the land fully described in the schedule herein below is rightly belongs to Srimoti Treasurer in an assembly, a resident of Chapel Road, Kualapatti, Srimoti Treasurer in an assembly who has right title and interest, and nobody can claim ownership over it, which is so far occupied Srimoti Treasurer in an assembly till date, and the land is also free from encumbrances. This is a certified copy of the village Rangbas Nong, Nongpo proper. Yes. Then 302, it is 1452. I, the headman, along with executive members of the village Dorbar, Nongpur proper, certified and confirms the land which belonged to Treasurer Irene Siamli, a resident of Chapel Road, Shillong, to which has been purchased from Sri Promimuel Lingdo since the year 2003, which is situated at Nongpo proper, Downgate, as per the schedule of the shown below. This is the schedule.
Yes.
And that schedule is not. Declaration deed was thereafter made, Lordship.
See now, your seal deed will show that you have bought the land in 2003.
Yes.
But the suit was instituted in 1999.
Yes, Lordship.
So it was during the suit period that this land.
Yes, I have purchased. I have not denied that I have not purchased. There is some provision how to assign the property to other.
No, that is.
I will show, Lordship.
In the midst of a suit. In the midst of
during pendency of the suit, during pendency it is lease pendants. Otherwise,
yes, it is
lease pendants. During pendency suit, how can the property can be assigned to transferee?
How can it be? How can it be alienated?
Yes. That is also I will go to by CPC.
CPC.
Yes, Lordship. Declaration deed, Annexure 12. That was registered.
Page,
Lordship, 304. Because people going to proper adjudication of a matter, I have to show everything, Lordship. Annexure 12.
Yes.
That was registered before the sub-register Nongpo, Lordship.
Yes.
Annexure 19, Lordship. Notice was served.
Page, Annexure 19?
Annexure 306. Annexure 13. Annexure 13, 306.
Yes.
To TICMLA, Nongpo, Lordship.
Yes.
Acquisition of land for construction of four-laning, petitions thereof. With reference to the subject indicated above, and as per our petitions, I am to inform you that Extra Assistant Commissioner Revenue of this office, along with representative of National Highway Authority of India will conduct a joint survey, demarcation of the land as per program below 185/2009 from AM onwards.
Yes.
That notice was given to her, to the petitioner, for acquisition of land in the name of construction of 4 laning.
Yes.
That original copy, that is a photocopy, 308. I have annexed. That is type copy, Lordship.
Yes.
Then Annexure 14, page 309.
Yes.
That notice also given to the, it is general notice. It was given to TICM number 5, last portion, in memo.
Yes.
After the memo. TICM, Lordship. For
Yes.
a small portion of the my building,
Yes.
they have demolished one part, Lordship, 10 feet. 10 feet of the building. That building, petition's building was 60 feet length and 30 feet wide. Then 10 feet they have demolished at the time of acquisition.
Okay.
And that portion, and a portion of land, a case was pending before the LA case was pending before the learned court of special judicial officer, Rivoy district.
Yes.
In front of that, in this building, I got compensation also for building and land also. That was, I have annexed as page 13 on 8/7/2010. (312) and 313. I have typed copy 312. Annexure 16 and 17. For building and land, I have received, Lordship, 2 compensation, 78,000 something and 19 lakhs something, 80,790.
Okay.
For my building, wherefrom I have been dispossessed.
Okay. And there was no objection to this.
No, that time I have received compensation. There is no objection, anything. And thereafter, after demolition of one part, Lordship, again the petitioner reconstructed the building in backside, extending the same 10 feet again. Now it has become 60 feet length and 30 feet breadth. It is still standing over the land.
Okay.
And the boundary shown therein is not the boundary of, that is different boundary, Lordship.
Okay.
Now, Lordship, I'll show, this is the main theme there. They have mentioned about some of the...
We'll do one thing then.
Sir, Lordship.
We'll continue on the next date then.
Next date, Lordship. Then for a date may be fixed, Lordship, because I have to move some other...
No, you decide on the date.
14, Lordship.
Mr. Deva?
14 of...
14?
Yes, Lordship. June.
Fine. Learned Counsel, Ms. MDEP, Learned Counsel for the petitioner. This matter has been partly heard and hearing to continue on the next date fix. As agreed to by the parties, this is matter on 14 for the hearing.
14/6.
14/6.
Obliged. I do obliged.